Hi comrades, yours Kayveeyes.
I am totally disappointed. Before commencing the topic and also discussion on the notional increment Supreme Court final decision, I am actually dismayed and disappointed. The Supreme Court has issued its judgment in the case of Siddaraj and others on 20th February 2025. It has confirmed the decision dated 11/4/2023 in the same case earlier on the ground of notional increment. And it has stated that this will be given effect to the third parties. That means third party means those who have not approached the legal remedies. They will be given from the date of judgment, that is 11/4/2023, and the increment will be payable on or after 1/5/2023 in their cases. The enhanced pension for the period prior to April 2023 will not be paid to those who have not approached the judicial remedy. In the final order issued on 20th February, they have just clarified Class D only. So far the Class A, B, C of the original judgment dated 11/4/2023 that has been confirmed. Only in the Class D, a slight modification was there that it is allowing the enhanced person only for 3 years and not for the previous periods. Earlier, it was given from the date of their superannuation. That has been restricted for 3 years from the date of application of the court case. So that is also applicable only for those who have filed the cases and they were pending prior to the issue of Siddaraj orders on 11/4/2023. That is a subsequent clarification issued in the same orders. The 3 years enhanced pension, we have discussed in our earlier episode also. Based on a Punjab case, the Supreme Court has held that arrears for 3 years will be sufficient in such cases. The same has been cited by the government in the review petition. The same has been accepted by the Supreme Court. And based on this, the arrears for any fixation is now limited to 3 years. This is a very dangerous proposition. In all other cases, whether it is for the commutation of pension or whether it is for the reserved trained pool in the Postal Department, this will be applied in the future also. There is a dangerous proposition so far these 3 years conditions laid down in the Supreme Court orders. And also, those who have filed any applications either in the CAT or in any court, High Court or anything, after 11/4/2023, that will not be entertained, whatever be the judgment, that will not be entertained, and they will be given effect only from 11/4/2023. So before issue of the Siddaraj case judgment on 11/4/2023, whoever filed the case, they will be get the benefit for 3 years from the prior to the date of filing the court case. But others who have filed the case after 11/4/2023, they will not be given any benefit with retrospective effect. This is very clear. Whether they have gone to the court or not, that is immaterial. They all will be given the benefits only from 11/4/2023. And also the most concern that in the order they have not mentioned about the applicability of notional increment. The government of India has already clarified that the notional increment will be applicable only for the pension fixation, not for any other pensionary benefits. Because of this, they did not get any pensionary benefits so far. A clear-cut clarification has not been issued by the Supreme Court in this order. It was vague and simply left out. So the government will implement the notional increment only for the pension fixation and not for arrears, that too from 11/4/2023. There are many pensioners who are awaiting justice in this case. It is definitely a great disappointment to them. Actually, the JCM staff side has further discussed this issue with the government, and also they should seek the clarification that the notional fixation of the pension that should be applicable for the pensionary benefits also, And also the 3 years condition that should be relaxed hereafter because the Supreme Court has passed orders. It is in nobody's hands. If the government consider, it is all right. If not considered, we cannot do anything more beyond the Supreme Court decision. Otherwise, we can file another petition and it is a very lamba process, very lengthy process. And there is no guarantee that the employees will get the justice. From the beginning, the government, after the 11/4/2023 judgment, they have put the review petition, first review petition, second review petition, curative petition, and so many petitions one after another. And finally, they convinced the Supreme Court to restrict the arrears for 3 years. And also, it will be applicable to others who have not approached the court after 11/4/2023. A very great disappointment. The government has to considering the welfare of the pensioners, and they should be given due justice as per the earlier decision taken in the case of I.M. Perumal. That will be the correct solution in these cases. With this, I am concluding. With heavy heart, I am concluding. Thank you very much. Meet again.